5, 4, 3, 2, 1. Learned counsel for the appellant spent considerable time taking us through the various evidences on the record with the intention of highlighting lacunas and contradictions. We feel that such an exercise was in vain, as the threshold of interference in the present proceedings is quite high. The power of judicial review discharged by constitutional courts under Article 226 or 32, or when sitting in appeal under Article 136, is distinct from the appellate power exercised by a departmental appellate authority. It would be gainsaid that judicial review is an evaluation of the decision-making process and not the merits of the decision itself. Judicial review seeks to ensure fairness in treatment and not fairness of conclusion. It ought to be used to correct manifest errors of law or procedure which might result in significant injustice, or in case of bias or gross unreasonableness of outcome. These principles are succinctly elucidated by a three-judge bench of this court in B.C. Chaturvedi versus Union of India MANU/SC/0118/1996, 1995, 6 SCC 749 P12 in the following extract. Judicial review is not an appeal from a decision but NV JWP number 2893 of 2023, a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of the court. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is concerned to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with, whether the findings or conclusions are based on some evidence. The authority entrusted with the power to hold inquiry has jurisdiction, power, and authority to reach a finding of fact or conclusion, but that finding must be based on some evidence. Neither the technical rules of Evidence Act nor of proof of fact or evidence as defined therein apply to disciplinary proceeding. When the authority accepts that evidence and conclusion receives support therefrom, the disciplinary authority is entitled to hold that the delinquent officer is guilty of the charge. The court tribunal, in its power of judicial review, does not act as appellate authority to reappreciate the evidence and to arrive at its own independent findings on the evidence. The court tribunal may interfere where the authority held the proceedings against the delinquent officer in a manner inconsistent with the rules of natural justice or in violation of statutory rules prescribing the mode of inquiry, or where the conclusion or finding reached by the disciplinary authority is based on no evidence। इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है।